A very good day to you and welcome to the Morning Latte Game Changer program. This program has been proudly brought to you by Conrad Adenauer Stiftung. Today we're going to be talking about misuse of state resources, something that we have sort of become accustomed to as citizens of Zimbabwe. But is it right at the end of the day? I don't think so. And we'll be getting into this conversation in a little bit. Misuse of resources is a breach of public duty. And obviously we know that public resources are there to enable policymakers to do their job, which is to serve the public efficiently, effectively, and impartially. And everyone working in the public sector has a responsibility to act in the public interest and of course have appropriate use of these resources as a part of their responsibility. We recently got some interesting news where we had the High Court giving the Minister of Justice, Legal and Parliamentary Affairs, Ziyambi, 45 days to develop a code of conduct for vice presidents and ministers. And it's quite interesting that this application was brought by a former Zimbabwe Ezekiel University law student, Nyasha Chiramba, who approached the High Court seeking to compel the Minister and Attorney General to initiate the drafting of the bill envisaged under Section 106 of the Constitution. We'll see as we break down our segments, as we get into the program, that we're not only going to have Nyasha Chiramba, who is of course the young legal practitioner who was the applicant, but we're also going to have Darlington Marange from the Zimbabwe Human Rights NGO Forum, who is Chiramba's lawyer, who is representing him, and of course Fadzai Jekemo from Transparency International Zimbabwe, to talk a little bit about what misconduct really means. Nyasha, how are you today? Thank you for joining me as our game changer.
Thank you so much, Unique. The pleasure is mine being here and sharing the experience with the world.
Fantastic, Nyasha. Quite interesting. A young person goes to approach the High Court seeking to compel the Minister and Attorney General. And you argue that vice presidents and ministers and deputy ministers have been involved in different types of misconduct and, of course, abuse of state resources. What led to you actually making that move of going to the High Court?
Okay, thank you for the question. Honestly, what made me to approach the High Court was that if not me, then who has to approach? Because we're lawyers, or we were young lawyers by then when I was still at Zimbabwe Ezekiel University, starting my LLB degree. And we then pitched out an idea, and we got to appreciate that there was need for us to approach the court, since it has the mandate in terms of the Constitution to mandate a certain public officer who is in this scenario the Minister of Legal, Justice and Parliamentary Affairs, so that they can be compelled to create a draft or a public policy framework system or kind of system, which is more or less the code of conduct that we're looking into in being specific. So I just took the arm and say, when we were reading in law school, we used to find Tawanda Nyambirai versus National Social Security Authority, and I was telling myself that, okay, I think it's high time for me to be the Nyambirai for today's generation, for me to just go up, because the High Court always allows any person, any individual to approach the court. So as a defender of the Constitution, as a defender of rule of law, as a defender of constitutionalism, I mandated myself and said, no, there's need for me to push and approach the High Court, because that was the only recourse that we could get. Particularly if you go back to the history, you see that this application came soon after we had the scandal of the dismissal of the then Honorable Vice President Kembo Mohadi. So those were the issues that were still bottling up, and we had to make sure that not only the voices that are known, they have to wait to be heard, but we also had to give a voice as the youths solely from the law school.
Definitely a bold move, and of course you've answered a key question. If not me, then who? You must be the change at the end of the day. But let's break it down a little bit, Nyasha. What constitutes misuse of government resources? What are government resources? Because as citizens, we want to know when we talk about misuse of resources. We've been talking about corruption and all of that, but what constitutes the misuse of government resources?
When we're looking at the concept of misusing resources, definitely in the context of this judgment that was granted by the High Court, we have to be considering the notion that as a state or as an entity or as a government, we have the concept of accountability.
Right.
There are resources that are poured in by the taxpayers. There are resources that are poured in by the majority. There are resources that are poured in by each and every citizen or participant in the system. So what we then try to look into is that we appoint certain individuals, or who are then called the executive members of the government, to be more or less the stewards of our resources. So when they fail to distribute in accordance to the concept that has been laid out within the four corners of the Constitution, then definitely it then shows that there is a breach of public policy.
Right.
Because the whole notion stems from public policy, and the concept of public participation has to be accounted for. So in this scenario now, for the betterment of the world, and in the context of the notion that we have today, I would then say the misusing resources would be the concept in which we understand that certain individuals or certain executive members, who is the Minister of Legal Justice and Parliamentary Affairs and the Attorney General, they have a role. They have the role to guard against the Constitution. They have the role to implement certain bills that are supposed to be implemented in terms of the Constitution. So their failure means that they've breached the social contract they have with the general populace, which is enshrined within the four corners of the Constitution. So that failure alone then brings a question that where are the resources being channeled when they are supposed to be channeled towards this duty that they are mandated to partake in terms of the contents of the Constitution.
You brought in an interesting word, which is being a steward. And being a steward, we understand that according to the dictionary, a steward doesn't necessarily own the resources, but takes care or looks after those certain resources so that they can actually help the public or the citizens of Zimbabwe. So you actually talk about the Minister and Attorney General initiating the drafting of the bill envisaged under Section 106 of the Constitution. Can we break down this specific section? Why do you link this specific bill with this section?
Okay, it's quite interesting for the interest of the public that breaking down Section 106, because I understand a lot of people do not have the utmost appreciation of the Constitution, particularly with the legal language that is encroached in it. But if you go to Section 106, it talks of the conduct of vice presidents, and ministers and deputy ministers. And it then, there are three subsections within Section 106. The first subsection 1 of Section 106 entails that every vice president, minister, and deputy minister serve at the interest of the president. And it then gives a picture that ministers and deputy presidents, they are supposed to serve within the mandate of the president. Right. And it then gives another interpretation altogether that the president himself, he has a duty to guard against the interest of the voters who then, or of the electorate, who have empowered him to become the president. So once that is the main mandate of the president, it means that the interest of the vice presidents, the ministers and deputy ministers, still falls within the confines of public interest, because they are serving for the electorate that has bestowed power upon the president. Then it goes then to Section 106 subsection 2. Subsection 2 entails that every minister deputy minister and vice president is supposed to, it can be summoned before the parliament.
Right.
So if we try to understand the concept of summoning before the parliament, we say these are members of parliament voted for by the people. In Zimbabwe, we have a representative democracy system. So the parliament represents the voice of the people. So once ministers who have not been elected to power, who have been appointed by the president, have to be summoned before the parliament, it means that they are supposed to be accountable, because as I have said earlier on, these ministers and deputy ministers and vice president, they are stewards. They are stewards of public policy. They are supposed to guard jealously against the public policy. So the parliament now has to act as a watchdog par excellence to check and mandate the minister on certain issues that are arising from their own ministries that they would have been assigned to work on. From that perception, it then gives us a picture that we are appreciating democracy. We are appreciating the role that is supposed to be played. But at the other end, we are now saying, these are executive appointed members. They are not elected members of parliament. They are executively appointed. Yeah. But at the end of the day, we are not having anything that is guarding them, or that can be used to chastise their waywardness, or that is used to chastise their movements, or to govern their conduct. Mm-hmm. So we then come up with section 106 subsection 3. Which then say, there shall be a bill enacted to govern the conduct, or more or less a code of conduct for these executively elected members. Mm-hmm. So with that, now section 103, that's where the application we made before the court was centered, to say, okay, fine. We understand we have stewards, we have people who are representing us, because if ministers at one point, they are able to even make what we call statutory instruments, which then become the law and affect people, because they are working with a certain ministry as they are trying to make life easier for the government to function properly. So we cannot be having people who are stewards without having a code of conduct against a steward. And who would want to appoint a steward who can to wake up in the morning and start to say, I'm doing this, I'm doing that? Yeah. Definitely, we have the president who was using his power as the president to remove someone from power. You understand, when I've said it earlier, when we made this application, it was the days when Kembo Moadi, the then vice president, was dismissed from office. Yep. But before that, we had people like Fortune Chasi, Priska Mfumira, and the likes, and it did not stop there. Even right now, we have recently gotten a deputy minister being dismissed from office. Mm-hmm. So we do not just want to have someone who just come to say, because the president has appointed them. Yes, the president has appointed them because the constitution says so. But the constitution then goes on to say, no, there should be a code of conduct that is to be that is to be enacted, so that we govern. Because if we tell you that you are supposed to go to Harare, when you are from South Africa, you can tell yourself that I can either go by the bus, or I can either go by A, or if there is rail, I can use rail. Mm-hmm. But if you are told that you are supposed to go to South Africa by road, it means that you are supposed to go by road. You get the point? Mm-hmm. Whether you use the other route of going in Botswana, then you go to Zimbabwe, but you're using the road, because that's the code that you have been, that's the agreement that has been reached. Yeah. So this is more or less the system that we wanted to say. No, okay. The Constitution it was enacted in 2013. The Constitution survived. It's now about 8-9 years from now. You get the point? Yeah. Calculating. Mm-hmm. We have 9 years running. We have the Constitution. But we have not yet gotten this code of conduct. And we still have ministers. And without a code of conduct, it does not mean that we won't have ministers. Ministers are there. But we still need that code of conduct, so that the public would appreciate that at least there is this, at least there is that. And at least the minister is breached clause 5. At least the minister is breached clause 4. Because they are public officers. They are in the office that every Zimbabwean is waiting, because there are resources that have been chucked into that office.
as we round off this conversation with you, Nyasha, what difference do you think this application is going to make, since the High Court has given Minister Ziyambi 45 days to develop the code of conduct for vice presidents and ministers? Do you believe it's going to make a difference, especially when it comes to, holding ministers accountable for misuse of funds in that ministry? As you already said, that when we have, for example, Ministry of Women Affairs or Ministry of Mines, every citizen is looking to that ministry that it might channel the funds appropriately to better the citizens.
Before I answer your question, I would like to say this. Maybe it becomes a bit lighter. Everyone remembers the days of the former Minister Jonathan Moyo, when the Zimdev scandal was still on the fire. It was boiling when the pot was about to spill. And the then President, Robert Gabriel Mugabe, then appeared before a youth interface and just said, go and tell them what you did with the money. When he was being tried to be apprehended by Zimbabwe Anti-Corruption Commission. So it gives a more or less a different picture as of what we now have today, with the High Court ruling in our favor, that every minister, every deputy minister, every deputy president is going to be accountable. And there is no longer that private life, because it's a public office that you're holding. Yes. Every individual should know that when you have failed to apprehend certain clause within the code of conduct, this is the decision. Not to wake up one morning and you see a presidential praise from the president's office saying the president, with his powers, he has decided to dismiss so and so on the basis of 1, 2, 3, 4, 5. But the public then has to ask, what was this basis? Because once we have a code of conduct, it then gives us even a position where these ministers can go for public hearing. Yes. And we understand he gives his position because he's still a civil servant. Yeah. He's serving the nation. So it gives a picture. I think that's the change that we're looking into, because it may not be efficiently executed as we would like to, but definitely it will progressively reach there.
It's a step in the right direction.
It's a step in the right direction, definitely.
Well, thank you so much, Nyasha. That was Nyasha Chiramba, who is a former Zimbabwe Ezekiel Guti University law student who approached the High Court seeking to compel the Minister of Justice, Legal and Parliamentary Affairs, Ziyambi, and Attorney General Prince Machaya to compel them to initiate the drafting of the bill envisaged under Section 106 of the Constitution, which he broke down for us. And as he said, if I am not the change, who is going to be the change at the end of the day? Vice presidents, ministers, and of course their vices are supposed to be held to account, and they need to be good stewards of the resources, as the citizens of Zimbabwe are looking to those resources to be used for the betterment of Zimbabwe. After the short break, we'll have Fadzai Jekemu, who is from Transparency International Zimbabwe. Fadzai Jekemu is a human rights activist, but we'll also look at some case studies of presidents that have, vice presidents that have actually also left office due to misconduct. We're going to look a little further into this sort of misconduct. What sort of misconduct are we talking about? We're talking about sexual harassment that is swept under the carpet and so much more. We'll be right back. Welcome back to the Game Changer program. As of course today we are focusing on misuse of resources being a breach of public duty. As we said before, the High Court has given Minister Ziyambi 45 days to develop the code of conduct for presidents and ministers. And this order has come after a former student of the Zimbabwe Ezekiel Guti University, Nyasha Chiramba, approached the High Court seeking to compel the Minister and Attorney General to initiate the drafting of this bill. Former President Kembo Mohadi was forced to resign after the audios of his sexual escapades went viral on social media. We have with us right now Fadzai Jekemo from Transparency International, who's going to talk to us a little bit or unpack, the challenges of misconduct, the types of misconduct that we have, and why they're all really being swept under the carpet and no one is holding our ministers or vice presidents to account. Fadzai, how are you today?
I'm very well, thank you. How are you?
I'm very well. Thanks so much for joining us as our game changer. So, Nyasha, quite a bold student, goes, does the application and makes waves and noise to the point that the High Court actually gives Minister Ziyambi 45 days to create this law or bill. Let's talk a little bit about the types of misconduct, including sexual misconduct that we see ministers are involved in, or their vices or vice presidents. Where is this the challenge, especially when we see that most of these cases go unreported or they're swept under the carpet? Why does it play such a critical role, especially to you as a representative of Transparency International?
Thank you very much, Unique, for that question. So I think what we need to look at is what constitutes misconduct as far as the criminal code is concerned. So, for example, we've got crimes like bribery, we've got crimes like extortion, we've got crimes like fraud. Mm-hmm. And these are not only for the members of the public, but we see even the top executive or the politically exposed persons committing the same. We also have misconduct where we've got influencing public procurement processes, awarding of tenders to unqualified people. So such things, they do institute misconduct.
Right.
But I think what I need to make emphasis on is the case at hand, which Nyasha has been awarded by the High Court. It then comes to a certain term which is called sextortion, mm-hmm. whereby sex is used as a currency for bribe. So I think, yeah, those are some of the misconducts that we have.
Okay, so why does this code of conduct, especially when we're looking at sexual misconduct, what has been the biggest issue around sexual misconduct, especially when we look at our former case study, which we're looking at, of Vice President Kembo Mohadi forced to resign after the audios of his sexual escapades went viral on social media? What are the big challenges there when, of course, we have a policy or a law that doesn't really control what ministers do at the end of the day? What could be the ripple effect?
Okay, so the effect is most of these cases, they often go unreported.
Right.
Because they happen in private.
Yes.
So when we speak of sextortion, it's a willing buyer, willing seller kind of transaction. But that doesn't make it legal. So if we are not making it illegal, we need to have ethical values to make it unethical. Mm-hmm. So if there is a code of conduct which regulates the behavior of ministers and those in the executive, Unique, you agree with me, if the powers that be comes to you personally and comes and say, Unique, this is what I require from you, mm-hmm. whom do you go to report to?
It's a challenge. It
is a very challenge and it's mm-hmm. scary. So if we have a code of conduct that is actually telling us that if they do this, then this is what's supposed to be done by the employer. The employer obviously the government, and who's the government? It is us, the people. Mm. So I think that's what we need.
That's fantastic. And I mean, just like, as I was rounding off with Nyasha, what difference do you think this application to the High Court will make, especially as we look into the future, we look at the challenges that we've been facing? As Nyasha said, that our constitution has been in existence for almost 9 years now, mm-hmm. But we've been seeing these challenges often go unreported, or they've become part of us, a sort of a culture, if I'd like to put it that way. I mean, do you see any difference that this policy or law could possibly make?
Okay, from where I'm standing, I think it will, of course, it will not only address issues to do with sexual harassment. Mm-hmm. It will also address issues to do with integrity. It will address issues to do with abuse of power. It will abuse of office. It will also address issues to do with accountability.
Right.
So there are a lot of issues that even the Auditor General has exposed that the ministries or the politically exposed persons are doing and often go unpunished. So this code of conduct will help us to then look at the nitty-gritties of what is expected of a public official and in that part of the organogram, and also what we need to do as the CSOs. We will have a point of reference. Beyond the Constitution, we'll have a point of reference to say, this is what the Code of Conduct says, and this is what we require of the people in the office. So they'll be accountable to us, I believe.
That's fantastic. Thank you so much. That was Fadzai Jekemo from Transparency International Zimbabwe. As we're talking about, looking at issues to do with the code of conduct, misconduct that ministers have obviously been sort of going through, and also, as we look at vice presidents as well, and looking at the transparency and accountability aspect of it. After the short break, we'll have Chiramba, lawyer Darlington Marange of the Zimbabwe Human Rights NGO Forum, telling us a little bit about the political will behind, this policy. We know that the Constitution has been in existence for the last 9 years. Will this application really make a difference, as he was standing on Chiramba's side? We'll be right back. Welcome back to the last segment of the Morning Latte, a game changer. As of course, today we're focusing on misuse of resources being a breach of public duty. We started the conversation with Nyasha Chiramba, who approached the High Court seeking to compel the Minister and Attorney General to initiate the drafting of the bill envisaged under Section 106. And of course, his argument was vice presidents, ministers, and deputy ministers have been involved in different types of misconduct, including sexual misconduct and misuse of state resources. Right now with me, I have Chiramba's lawyer, Darlington Marange of the Zimbabwe Human Rights NGO Forum. Darlington, how are you today?
I'm good.
So you're the big man who
Yes.
is standing up for, what Nyasha Chiramba believes in. And he definitely believes that, our ministers, our deputy ministers, and of course our vice presidents should have a law that guides them in terms of use of resources. Tell me something, Darlington. As Nyasha's lawyer, you're pushing for a law that will stipulate this code of conduct. Why does this law matter, and why do you believe that Nyasha has a point to make there?
Yeah, thank you. I believe that this law matters as a matter of principle. The Constitution says there should be a law that actually stipulates the code of conduct, and the Constitution is the supreme law of the land.
Right.
So it should be a law as a matter of compliance, as a matter of rule of law. So this law matters in that regard. And secondly, if you look at the code of conduct and the appointing authority, who is the president, it's actually very important for the president to actually monitor the conduct of his subjects, like the officials that he appoints. So it will be a yardstick to measure their conduct so that they do not demean the decorum of the offices that they hold. And as a matter of accountability, these guys need to be accountable to the people of Zimbabwe, to the public, and to the president as well. So I think that in that regard, it is very important. We do not want a minister that demean the offices that they hold, involved in other issues that have been already alluded to. And then also, the code of conduct, it is very, very important, because we are expecting that it will have a mechanism where members of the public or those victims that might be affected by the certain misconducts will have a recourse. So it is in the interest of access to justice, so that these guys or these victims might actually report some of these misconducts. So in that regard, I also think that this code of conduct matters. And also there's need, we have seen a trade where the president actually dismissed certain minister that you can question the the allegations that were put forward against them. The issue of maybe I will start with the former Vice President Mnangagwa. He was accused of deceitful unreliability, disloyalty. You question whether he was suitable even to hold the office of the president that he actually hold it like now. So you would find the president just settling political scores and actually just throw these allegations that are not codified. So the code of conduct will be very important because it is out there for people to actually see on whether the minister is actually involved in misconduct. That will put the president in the public scrutiny, in the public opinion, sort of like. So I think it's very important in that regard for people to actually scrutinize the action of the president, because they will be referring to the code of conduct. You have the people like Fortune Chasi, who was also dismissed in circumstances that you think you actually cast some doubts on whether he was not suitable for the ministry that he was holding, because you believe that he was delivering, and all of a sudden you get these allegations. So codification of this ethical standard that we want is very, very important. It will actually measure, you actually question the decision of the president as the appointing authority. You actually, it actually comes up with an accountability mechanism that you, something to do like that.
Great. Talking about, being accountable and transparent to the citizens of Zimbabwe, why do you think we've had this challenge for decades? Is there political will to actually bring to book those who are abusing state resources and those in different types of misconduct? We still have, I think, about, let's say, about 40 to 35 days left until, of course, the Minister of Justice, Legal and Parliamentary Affairs, Ziyambi, and Attorney General Prince Machaya craft a law. Is this going to actually happen? And let's go back to the political will.
Yeah, I think there's no political will, to be honest. I think we have systemized the issue of corruption, the culture of corruption, and we do not want to be accountable, not only to the deputy ministers or the ministers. I think it's a culture that we have perpetuated in our society. So actually that will actually affect even our governance system. I don't think there's a political will for the president, for the ministers, and all other relevant stakeholders in the lawmaking process to come up with that law. In these circumstances, a law student wouldn't be expected to go to High Court to actually compel the Minister of Justice to actually come up with a bill on a constitution that was enacted 9 years ago. Minister of Justice is the leader of the government business in houses, in National Assembly. He is also he chairs the cabinet. He is also someone who is assigned to oversee the constitution itself. He cannot promote the constitution without complying with it. So I think there's no political will. You will get some sentiments from the Office of the Attorney General indicating that we are coming up with a research paper, but you count more and more years. This is not, we are expecting that they will rather amend the provisions that they think they don't agree than complying with it. So I don't think there's political will. That's why Nyasha actually take that action of approaching the High Court.
Okay, but Darlington, do you believe that this law is going to be crafted in the next 45 days?
Yes, it's a court order. Yes, of course, of late we have been seeing some worrying trends where the government actually might disregard court orders. But in the interest of the rule of law, constitutionalism and supremacy of the constitution, and the issue of social contract, remember that our constitution actually embodied the aspirations of all Zimbabweans, and actually these guys are governing out of that consent from the electorate to govern us. So I expect that they will comply with the court order, because the courts are the custodians of the constitution. So we expect that they actually comply with that court order. There was a decision which was given also in similar cases like section 210 the independence complaints mechanism, where the cabinet was given 45 days to actually submit the bill to the parliament, and they complied. We are yet to see today on whether this decision or this will be debated in parliament.
Yeah.
We're actually looking forward to see the minutes on whether the government are taking this seriously. If they are not taking this seriously, then you actually go back to the court and actually force compliance. Yeah.
Lastly, Darlington, now that you know you have obviously the judgment, what is the way forward?
The way forward, as I already indicated, is to make sure that we monitor compliance about this the whole issue. We expect that the government will actually comply with this judgment. If they do not want to comply with this judgment, we actually expecting that they may take some recourse in terms of the constitution or whatever. But we expect that they comply because it's a clear case where the Minister of Justice has to just craft a bill and present it to the cabinet. It's a simple task. So we expect the Minister of Justice to comply with that. But we are also, we shall be engaging the Minister of Justice in our lobby and efforts, initiatives to make sure that we actually pushes him for the construction, for the development of that bill. So we shall be engaging we shall be sitting together and actually craft some strategies. If they need our input, we can actually come up with some bills, actually with a draft bill, to present it to them for their consideration. And I think those are the things that we are expecting. And yes, as I already indicated, if they failed to comply within 45 days, then we have to go back to the court.
Well, thank you so much. That was Darlington Marange, who is representing Chiramba from the Zimbabwe Human Rights NGO Forum. As of course, today we were talking about misuse of resources being a breach of public duty. We have a former Zimbabwe Kyoguti University law student, Nyasha Chiramba, who approached the High Court seeking to compel Minister Ziyambi and Attorney General to initiate the drafting of the bill envisaged under Section 106. As of course we look at ministers, deputy ministers and vice presidents who have been involved in different types of misconduct and misuse of state resources. At the end of the day, we did say that, you know, if we have policymakers, they are stewards of resources to better the nation or to better citizens of Zimbabwe. This program was proudly brought to you by Conrad Adenauer Stiftung, and we'll see you next time.